Hi everyone, my name is Edna.
And I'm Marcy.
And this is The Real Conversation.
Your trusted guide in everything real estate here in Kenya.
And we are proudly brought to you by Centum Real Estate, the biggest mixed-use developer in East and Central Africa.
And today, we are going to be continuing a conversation from the last episode. We talked about wills, we talked about trusts, and we're just going to expand this. We're going to talk about instruments you can use to help you in this journey. And we are joined by the lovely, lovely Judith Kamoing. And let her introduce herself again for the people who are coming for this episode and they haven't watched the other one. So, hi, Judy.
Hi, how are you guys?
Great. Lovely to have you back.
Yeah.
Thank you. So my name is Kamoing Judith. I'm an advocate of the High Court of Kenya and all the courts, actually.
Mm-hmm.
I am your commercial and estate and business planning attorney.
Mm-hmm. And as we were waiting to start this episode, there's something we've discovered.
Yeah, apart from being an advocate of the High Court of Kenya, she can also sing.
Yeah, she has a very nice song. And she also has a really cute initiative. Maybe you can tell us more about it.
Yeah, as part of our CSR at Kamoing and Company Advocates, we run Her Dreams Initiative Foundation. Mm-hmm. Her Dreams Initiative Foundation. Basically, this is a foundation, that sponsors girls, teenage mothers, and victims of sexual and gender-based violence, through their secondary school education. So we set apart part of our fees to actually sponsor them.
Wow.
We believe in giving deserving girls a second chance at life, because you'll find that these are girls who have become teenage mothers not because they wanted to, but because of defilement and such things, and they are not able to perform so well.
Yeah.
So we run that. We believe in affirmative action at the right level.
Wow.
Yes.
I think we're going to come and support you. Do you guys have events?
Yeah. Yes, absolutely.
Yeah.
And I think that is something that we can explore more about and see how to support these girls. We have our first two beneficiaries doing their exams.
Wow.
Form 4, they have been performing really, really well. So I'm really excited about that.
Wow.
You can see even in your eyes,
yes, absolutely. I'm so excited about it.
Yeah.
I'm excited to see them finishing school. Then we need to plan on now what happens after that.
Yeah.
About their college, their universities, and all that. Yes.
We're going to plan a day at least so that we can come support you even as a podcast, and even if our listeners would like to support the cause and everything. It's a cute initiative. It's really good.
Needed.
Yeah. So I think we can get to the episode.
Yes.
What we are here today to discuss. Last time when we were talking, I think we say that wills and trusts sometimes are not enough, and people need to have systems in place to help them during their passing. And I would just want you to quickly mention there's this thing that the will has to go through probate. So maybe that's why a will and a trust sometimes it's not enough. So could you just explain quickly overview about it?
All right. So probate basically means, in Latin, it means to prove. So every time you hear that word probate, it has to go through probate. It means that it has to be proved. And what is the court really proving? That you actually wrote the will, that the will was properly witnessed, by two people, that you did it voluntarily. So you're basically proving that whatever it is that someone wrote was actually written by that person. They had the intention to, distribute their estate the way they have written and all that. Yeah, so it is to prove the will or to authenticate the will. So in a will, you basically elect an executor, All right. And then the probate process takes like 6 months. So the first thing is that the executor, there is the first gazettement, and you're given the grant, the initial grant. Then after 6 months, you go for confirmation of grant and distribution of the estate. However, most processes are not that straightforward.
Yeah.
All right, because you can have someone coming and saying, yeah, you presented this will, but the deceased had another will, so it really complicates things. Yeah. Or when someone raises the issue of the deceased, did not have the capacity to make this will. They were not able to make this will. Yeah. Either they had an infirmity that basically probably they couldn't talk, they couldn't write. So how is it that this will has been made? So there are so many things that can come in between, and the will can be contested. So in as much as you wish for the will to take 6 months, then the property be distributed to the beneficiaries, it does not always happen like that. Sometimes it can even take years, and sometimes the will can be kicked out, and now you go back to intestate. Yes, pretty much.
And this is really not ideal, because as much as there was a will, or there is a will, everyone is still in a state of limbo. Even the property itself, no one knows what to do with it until all the property is probated, and we really don't know how long that could take. So that's why we've come today to have this topic. And while we were doing our research,
small research, I think there's one thing I saw called buy-sell. There are very many aspects, and I think we can start with buy-sell today. Buy-sell agreement.
Yeah.
What is it like, generally speaking, before we actually go to how people can make use of buy-sell agreements?
Yeah. Basically, buy-sell agreements are agreements. I do not think they're very popular in Kenya, but I think they're one of the agreements that people need to start adapting, in their businesses. It basically helps in business succession planning. And what exactly do we mean by business succession planning? We have we have asset planning for the individual, then we have business succession planning to help in the continuity of a business. So there are trigger events. A buy-sell agreement is basically an agreement that states what happens to the business, in case either if it is a joint business or a joint partnership, what happens if in case one retires, in case one dies, in case of incapacity. Yeah. So a buy-sell agreement basically dictates that. Yes.
So we can say, for this example, I think, and all examples through and through, we can let's use property.
Yes.
Let's use, I have a block of apartments. Let's say I have a block of apartments into Rivers. So a buy-sell agreement will say what will happen to this block of apartments during incapacity, death, retirement.
Yeah. So the first question that you need to ask is, if you have this block of apartments in Two Rivers owned in your name, then that goes to personal estate planning.
Okay.
Right? Are you doing a will? Are you doing a trust to commit that property into the trust? When you talk about buy-sell agreements, they are usually effective in businesses.
Okay.
So buy-sell agreements come in place or kick in where there are businesses. So if you have this rental property and you have formed a company between yourselves, the two of you, say person A and person B. Yeah. So you'll have a buy-sell agreement that will state, in case winner decides to retire, what really happens? How do we value her share in this business? Yeah. In case of death, what happens to her share of the business? What happens to the rental income? What are the trigger events? So the buy-sell agreement basically addresses three things. What are the trigger events? Yeah. So the trigger events most of the times are retirement, incapacity, and death. Of the other party. Then it states, in case of incapacity, what happens? If someone is no longer able to contribute into the business, into the running of the business, what ideally would happen? In case of retirement, one partner wants to retire. yeah, what happens to the business? Because basically you have left the other partner alone in the business. How will that business be run? What would be the expectation of this partner who is retiring? Yeah. Then thirdly, it answers to, in case of death of one partner or all parties, what really happens to the business? Yeah. So within the buy-sale agreement, you'll have different clauses. Yeah. You'll have, a cross-purchase agreement.
Okay.
All right, or a cross-purchase clause that basically says that in case Wena decides to retire, then her share will be bought by Mercy.
Yeah.
All right, then you can either have cross purchase or you can have a redemption. Okay. That it is the business that's gonna buy off your share. Yeah. Then it also answers to the question of valuation. How do we value this business in case this trigger events actually take place? Yeah. So you'll have different types of valuation. I think accountants are best suited to advise on how to value a business after a number of years. Yeah. But what is most essential, and also it answers to, in case of death, what really happens? One of the core things in a buy-sell agreement that people need to consider is how do you fund it? You see? Because in all these instances we are talking about, in case Wena decides to retire and she needs her portion back, or the business has grown and probably at that point you're making 500 million, what goes to her, given that she's no longer part of the business? In case of death, what really happens? Do you invite, the partner's spouse to come and be part of the business? Yeah. So funding is quite a crucial element in buy-sell agreements. I do not know whether you'd want me to go a bit deeper in terms of funding.
We can go. We can go deeper. We have the time.
Yeah.
We have the time.
So when you talk about funding, you can also decide on funding a buy-sell agreement. In case of death, the business can, as a matter of practice, pay for the life insurance of the members of the business, or of the two partners, or of the shareholders, or of the directors, so that at the point of death, the sum assured is paid to the beneficiary. Rather than them coming back into the business, then that amount, if agreed upon between the partners, is paid to the business. To the beneficiaries of the estate. Actually become the beneficiaries of that sum assured from the life insurance. So the structuring of buy-sell agreements, how you structure it, is very, very important.
From the get-go.
Yes.
This can also, now for property, this can work for people in Chamas.
Let's bring it back home.
So let's say Chamas, or in family businesses. I think last time we talked about some people, instead of putting it in a trust, they would prefer putting it in a company. Or an LLP, that thing. So I feel like this is also the same. This will also work for them.
Yeah, this ideally buy-sell agreements basically works best in businesses. Talk about a limited liability company. Talk about a partnership. A limited liability partnership.
LLP,
Yes. So there is a general partnership and an LLP.
Yeah.
So it works best in businesses.
Okay.
So in the case of heirs, I want this clarified. So this is a company, right? I have Judith has kids. Let's say Judith has kids, Edna has kids. I pass away. Do my kids have to come into the company? Because some people think their children will come into the company, or the children think dad has a company, mom has a company. When dad passes away, I'll go there. So is that the case?
Now, that all depends on how you first agree. If it is a limited liability company, then you have the articles of the company and you have the constitution of the company or the shareholders agreement that, first of all, I think lawyers should just go beyond incorporating companies basically for the purposes of it, but also looking at some of these things. So you just don't incorporate a normal company and that's it.
Yeah.
You need to look at the shareholders agreement. What does my client want? How do we structure the shares? In case of death, what provisions are there? Okay, so in a limited liability company, there are 3 things that could basically happen. You are a director shareholder in a company, both of you are director shareholders in a company, and person X dies. All right, so when person X dies and he had not planned, what would really happen to his shares in that company, it would go back to intestacy and it would be open to distribution by the court. All right. If person X dies and had willed out and said, these shares would be taken by 1, 2, 3, then that is what would happen. But then the willing out of those shares should not be contrary to the constitution of the company. Okay. Because if the company provides for the right of refusal, that the other shareholder directors have the first right of refusal, then you cannot will out before you float it out to the members of the company first. Number 3 would be, and I find that to be so effective, structure your shareholders agreement properly to even provide for trusts, and have the trust owning that share. Basically. I don't know whether I have answered your question.
No, you've answered my question.
Yeah.
Trusts, I think trusts are
where we should
Trusts are where we should be. Because it really simplifies everything.
Yes.
It's simple, but it's not simplistic.
Yeah.
Yes.
It helps everything look arranged in a certain level, but it requires a lot of a bit of effort paying your professionals and putting your things in order.
But also recognizing the fact that even in companies, it is not like if you're to get your son, probably who's an artist, and you're running a whole real estate property company, and this boy does not have, he has zero interest in either being included in the company. So the position they would take is a shareholder, not a director.
Yeah. And even besides the interest, the knowledge. Because I could be an artist. And I'm interested, but it's all about stocks and all those things and the capital markets. I have no clue. What am I doing there? So what do you do there now? Because I'm interested, but
you don't
have no business
knowledge.
Being here.
That's why I'm saying buy-sell agreements should kick in such instances. When you're able to know that we're starting this company and you're able to have, the last time we talked about exit clauses.
Yes.
And I was saying that it is basically very important in every situation to think about what's the exit clauses? How do I get out of this? In case this and this and this happens, what really happens? So I think we should have those exit clauses, and buy-sell agreement kicks in such a situation where you have said, in case of death, your heir cannot come in here. We already have the, the policy that would kick in and we would pay them this much.
That's easier.
Or we are going to pay your heirs, for the next 5 years, this amount of our profits, and after 5 years, then you will deem that your portion has already been paid off. Do you get it?
Yes, I do.
Yes. So buy-sell agreements kick in to basically provide for such instances so that you do not have just anyone coming into the company.
Yeah.
They do not have the knowledge that probably the parents had in running the affairs of the company. They are not competent. Can you imagine an 18-year-old coming to a big company, and they start taking management positions and decisions?
The company will fall.
Yeah, the company will fall. So buy-sell agreements kick in such instances to protect against such eventualities.
I think you've in part answered a question that I had, and I had written it, like, what if the company constitution is silent? Like, how do the heir is it heirs or heir? How do the heirs like divide the dividends or the rental income? So I feel like buy-sell agreement, it's really important if you have...
Yeah, buy-sell agreements are really, really important.
Now,
but also remember, if you do not plan your asset, then it goes to intestacy. Yes.
So is that in scenarios where the constitution is silent, we just have to go with
intestate?
We'll just have to go with it.
Yes.
Damn.
Oh, okay. Yeah. Or the internal agreements between the founders and all that.
Yeah. So I think we've talked about now buy-sell. There's this thing you mentioned called survivorship.
Yeah.
Let's talk about it.
Yeah.
The shareholder, company survivorship and director. Yeah, just explain.
Yeah.
In that light.
So in terms of property, we have two types of tenancies.
Yeah.
We have joint tenancies and tenancies in common.
Yeah.
All right. So under joint tenancies.
Yeah.
Hey, yeah.
It's allowed.
So under joint tenancies, joint tenancies basically come under survivorship. It's called the principle of jus acrescendi. Yes.
Just.
Yeah, just JUS.
Okay.
Okay.
Yeah. So basically, by operation of the law, if a property is jointly registered between two people, and the law views them as one unit. Yeah. So when one person dies, the survivor takes the whole property. It does not. It bypasses the court. It bypasses the court, probate and all that. It does not go to court for it to be validated. And you cannot will out this portion in a joint tenancy. Okay. And it mostly happens where it's between spouses.
Okay.
Yeah. So your share, by mere when you present the death certificate, then the person who is surviving gets the whole property.
The whole thing in full without being tested. Whatever.
Yes. And in a joint ownership, you can't will out your portion. You can't say, yes, we are married, but I'm gonna will out this portion of mine, a half of it, to baby 1, 2, 3.
Yeah.
That cannot happen.
Okay.
Yeah.
I have many questions from that because now this happens a lot. The both of you die at the same time. So for that property, the both of you have to agree. Since you can't will out a specific portion, the both of you have to agree
that this property
is
going to go to this person in case the both of you don't make it at the same time.
Now, this is where it's a bit interesting, where you're two spouses and one of them dies, then the property belongs to the surviving spouse.
Yes.
When the surviving spouse dies, then the property is free estate. It is available for distribution. So you can either, the surviving spouse can will out, or if they leave it like that, then it's going to go through court.
So even when they pass on, the both of them...
When both of them are not there, then the last surviving spouse, has died. Then the property becomes free. And the last surviving spouse can actually will it out to whoever they want to will it out to. Or they can just leave it like that. But then...
So when you're alive, in joint tenancy, you can't will out that property. The
No,
both
you
of you
can't.
cannot.
Oh, the both of you, if you agree, then yes.
Okay.
Yeah. If you both agree to that, then yes.
That's very important to know.
Yes.
So what happens now in the other scenario, tenancy in common?
Yeah.
Now, tenancy in common. And first of all, I think most people enter into joint ownership thinking that it is actually tenancy in common.
Yeah.
You know, you're married to person X and you say, hey, as long as jina yangu iko kwa title.
Yeah.
You know, not knowing that, yes, zile iko kwa title. But in case anything happens to you, you know, it might not really go to your kids. It will go to the surviving spouse. Yeah. So most people start out thinking that I want a tenancy in common, but they end up having a joint ownership.
Yeah.
All right?
Okay.
And it all goes down to how are your documents drafted? How is the sale agreement drafted? Are you stating that, you know, person X owns, you know, a half of the property of 50% and I own 50%? If there is that separation in terms of ownership, then it's a tenancy in common and your portion can be willed out without...
having to rely on
this
other person.
Having to rely on this other person. Yeah.
Okay.
So in a tenancy in common, you'll have 1 acre of land, you know, and both of your names are indicated. But then when you go to the title itself, I think I will give you a copy of a title and we are going to blur things out so that you see. In the title itself, you're able to see that this person owns these shares in this property and this person owns these shares in this property. That has to reflect in the transfer agreement. That has to reflect, and you must insist, especially to the registrars, you know, that the title has to reflect that it is a tenancy in common so that it is actually indicated. Because also when you know, lawyers do their work and they take it to the registrar, if the registrar is not keen, they will register it as a joint. Yes.
So okay, I have so many scenarios.
Yes.
I have so many scenarios on how this can go wrong.
Yes.
But I don't want to be negative, but I have to be realistic.
Absolutely.
Devil's advocate.
Higher. So, I'm married. I'm married to person X. Person X dies. Person X, we have tenancy in common. So if person X and I had taken joint, it would come to me. But now person X has died and we have the tenancy in common. Person X has children that I don't know, has a whole family that I don't know of. This family can come and contest and then take their shares. Can that happen? Or I'm just thinking around it, because now he has died, it's 50-50. He died without a will. Now we are in court. So is there a scenario like this?
Yeah, such scenarios happen, and it would not be treated any differently from... Now, first, another question would arise, was this matrimonial property? You know, so that if it is matrimonial property, then the surviving spouse is protected.
Yeah.
Yeah, remember we talked about matrimonial property and the protection that comes with that. Yeah. So that is number one. But it would normally take the same form that it would take for any other asset of the deceased where there was no will. You know, basically you'll go to court, you know, apply for letters of administration, you know, be elected as an administrator, you know, then there is that hierarchy of consanguinity to mean like, you know, in intestacy, when someone dies without a will, the first person who is entitled to your property and a life interest in your property is your spouse. Yeah. Then it goes to the children. Then it goes to, you know, your father and your mother. So it takes up that form. So if there is a child who comes in or a former wife who comes in, then the court really has to decide on how that property needs to be divided according to the units. If you're in a polygamous setup, then it's according to the units. If there are children, who are born out of wedlock, then the court needs to consider them. There are so many things that you need to prove in that.
Okay, so
yes,
my question would be, let's take now you have tenancy in common, but for an apartment that is generating rent. So when the person you're in the common tenancy with passes on, does it mean I stop taking rent because they died intestate? Let's take for the case they died intestate. Now I stop taking the rent or the proceeds from this unit, or what happens? Can I continue as they are contesting?
If you continue as they are contesting, then you will be viewed as an intermeddler. All right? Okay. You can take your portion, but then the portion that needs to go to the deceased family as they are doing their things needs to be set apart. So you do not take it as if it is your own property, because at the end of the day, you can be called to court to account, for the rental yields that belong to, your partner who is deceased.
So I can continue taking, but only my portion.
You can just take your portion, not everything.
Okay.
Yeah.
But we can to avoid all this, we can just set systems in place.
Please set systems in place.
To avoid all this. We can just say, if you guys are discussing how that will, let's have an agreement of how rent will be collected, of how the business will run, so that if the lift is not working, my tenants don't suffer. We can just have an agreement.
Yes, absolutely.
Okay. Higher. Now we've talked about rental property, tenants in common, joint ownership. Let's say for properties that are now in companies, do the heirs get the property itself? Do they get shares? Or what do they get? How does that process look like in succession?
Yeah. One thing that people should be very cognizant of is the fact that a company is a separate legal entity from the directors and shareholders of the company. All right? So by that separation, meaning if you have Wena and Company Limited and you have Wena and you have Edna, Wena and Company Limited is not Wena. The property of Wena and Company Limited are not Wena's property, and neither are they Edna's properties. And in as much as you bought it together, they do not belong to you. In as much as the company bought it, it does not belong to you.
It belongs to the company.
All right? That is basically called asset partitioning. So a limited liability company, has that asset partitioning mechanism so that the assets of the company are separate from the shareholders and the directors, all right, of the company. Now, your question is, where we have heirs of the company and, the main director or shareholder has died, and probably they willed out the shares. What do they get? They get the shareholding of the company, not the assets of the company.
The company itself owns the property.
Yeah, the company owns the property, not the individuals.
Yeah.
So unless the company decides to dispose of the property, however it will decide amongst the shareholders, depending on the voting rights and all that, then the company then can dispose to either the shareholders or the heirs or whatever.
I think
just being a director or shareholder does not mean that you actually own the property that has been bought by the company. So people need to be really alive to that. Because I have also dealt with instances where people think, I registered this company, we bought this property, so the properties are mine. The properties are not yours. The properties actually belong to the company. You're just a shareholder, you're just a director.
And even I have another question, or is it clarification from my end? So there's this property in a company, right? And there's there's Edna's property, and there's property that I had in the company. Well, in Wena and company, but I am with Wena in the company. So when my heirs are coming in, the property for Edna will go to family court, right? And the one in the company, for whatever dispute there might be, it will go to company's court, or so even the commercial court. So even the rulings will look different, or even the disputes are likely to look different, because maybe on this side it will be more lenient.
So you see, for your shares, it will go to your heirs. So when it comes to the company property, then that's a decision that has to be made by the commercial court. You know, if at all there is a dispute, because just because you have been brought in as a shareholder or director shareholder does not mean that you can take part of the property that belongs to the company. Yeah. I think not so many people really understand that distinction. People don't understand what it really means by a company being a separate legal entity. It means that the company, if it is Wena and Company Limited, you know, Wena and Company Limited is a person by themselves. Yeah.
It's an entity on its own.
An entity. You guys are shareholders. You contribute to the management of the company. You basically have, for the directors and the company, what's the relationship? It's more or less like a contractual relationship. You know? That's why we have directors' duties. What are the directors' duties? To do everything that is necessary to ensure that the objects and the purpose of the company are met. Do you get it?
Yes.
So in this scenario, I wanted to ask you, but I feel like we've already answered it, and I'll answer so that I can show people I'm a good student. Okay. So in this scenario, I wanted to ask you, how do companies like prepare for such scenarios when they're buying property, when they're buying land? It's having it in the constitution, just having that agreement and saying, it's important to have those exit clauses.
Yes, exit clauses. And remember, I also talked about the trigger events.
Yeah.
You know, what are the trigger events? What happens to this company property in case the trigger events actually are triggered? You know, so the shareholders agreement, the company constitution, the buy-sale agreement should be able to cater for such eventualities.
And for the people who are at home, and maybe your parent, or maybe you are considering purchasing property using a company, think about these trigger events. Think about how your company constitution is going to look like in case either of the shareholder passes on, incapacitated and stuff.
I see so many people incorporating companies for the sake of incorporating companies. You know, you just incorporate, and you have a company owning this, doing that. You have different partners coming in. You have different partners wanting to exit, but you have not provided that in your shareholders agreement, in your constitution. You do not even have a buy-sale agreement. I think people should, arise and shine. People should be awake, to certain realities, because eventually it happens. So as you sit down and you think, oh, we're having a dispute with Wena, but we bought this property needs to be divided into two. That's really not the case. That property is owned by the company. Did you have clauses that provide for, what are the dispute resolution, what happens in worst case scenario,
We should not incorporate companies for
the sake of incorporating company. But I see so many people
I have seen it personally with my own eyes. That's why I'm shaking.
You're shaking. People are just opening companies.
Because I know people have opened companies, and for good causes most of the time. Like, you want to start an organization, it's all these good things, but then when you realize it, as time moves forward, everyone is growing, right? So we might decide to purchase property together. We forget how we started. We did not start with exit clauses. We did not start with buy-sell agreements. Then things happen
but
in
also
between.
Largely, the problem comes in with incorporation of the company. If you do not want to get a qualified lawyer to do it for you, so that they can look at those things, because it's different. If you want a company incorporated for the sake of incorporating a company, I see people who even charge 20,000, 15,000 for just incorporating the company. But does it really meet your needs? You know, does it really meet the intentions of why this company was incorporated in the first place? Yeah. Does it meet, you know, the purposes of you guys coming together? Yeah. Does it ensure business continuity? Yeah. So structuring, I usually call it in my firm corporate structuring. That's what we do. Structuring of your company is very, very essential. You know, even when you have investors coming in, how do you structure that? How do you structure the shares within the company? Yeah, to accommodate such investors who are there just for 3 years, then they exit. How do you accommodate people who want to just pump in money, a certain amount of money? You know, probably you need the capital, the initial capital, but this person does not intend to stay there for a long time. What type of agreements do you have in place? You know, how do you really structure your company? So I think much thought needs to be put in it, you know. Because when you're starting a company, it's so easy. But when issues start coming up, you know, when these trigger events are actually triggered, then you have a big problem. And you do not even know where to start from.
And to bring it back home a bit, you know, someone at home might hear the word company and they say, oh, that's so big. Oh, we're not going to start a company anytime soon. SACCOs. Are SACCOs companies?
SACCOs are not companies. SACCOs are you know, the underlying legislation for SACCOs is the SACCOs Society Act.
Yeah.
And most SACCOs have bylaws, you know. And when you start making contributions into a SACCO, there are those forms that you're given where you elect who you're nominating. Yeah. So SACCOs actually have designated beneficiaries, meaning that in case of death, then whatever you're supposed to get from the SACCO goes to the person that you nominated, the nominee. Basically, yes.
So I have a quick question. You said in joint ownership, it will automatically go to the survivor.
Yes.
Like even if you guys go wheel it out, it will go to the survivor.
You can't even wheel it out.
You cannot even wheel it out.
Yes. By operation of the law, it goes to the survivor. What the survivor needs to do, take your death certificate, present it at land, Ifailiwe, and they have the portion and they have the name registered in their own name.
Okay. So in SACCOs, when you're nominating, does this have the same idea? Like, even if you guys go and debate it, if Edna mentioned Mercy as the beneficiary of whatever I have bought in this SACCO, no one will contest.
Yeah, no one will contest. Now, there are these processes that go beyond wills and trusts, as you were saying, you know, that basically do not form part of the estate of the deceased.
Yeah.
Yeah. And these are nominations where there is a nominated beneficiary. You know, you'll find it in retirement benefits, in pensions. You'll find it in life insurance. You'll find it in SACCOs, you know. Where there is a specific person who has been chosen. Yeah. So you can't even challenge that person. You know? And that is why it is very important to keep on updating your records, you know, checking on the titling, checking on the beneficiaries. Yes.
And for people who have bought, because the most common scenario I feel in Kenya with SACCOs, it's either people pay for fees and other things, but how about people who have bought land
as a SACCO?
You've bought land. We've gone. I've had my SACCO is buying land in somewhere in Kenya, and I am buying land with my SACCO. So how does that scenario go? And now, let's say, death and stuff. How... like the land.
So had you nominated someone who's supposed to come after you?
Edna.
If you had nominated Edna, then Edna is gonna get your portion. It really does not matter if Edna is a girlfriend from 26 years ago.
Yeah.
Whoa.
If you have not updated your records,
Yeah.
then that's simply it.
Okay.
Yeah. And you know, sometimes even when we are single, you nominate your parents.
Yeah.
Then you get your wife and you get your children, or you get
Children.
your husband and you get your children. If you do not update that, then it
will
simply
just go to
goes
them.
to them.
Yeah.
Yes.
Okay.
Yeah. So in case that person you had nominated dies before you do, yeah, then the portion would be available as part of your estate.
Okay.
Yeah.
So that happens.
Now they will the circle or the cooperative will nominate the administrator or the representative of the estate.
Of the estate.
Yeah, so that it is made available to the estate.
Okay.
Yes.
I have a very, I think it's a common scenario. I, as Edna, and as most parents do, they will write you as a beneficiary, yet you have no clue, right? So the parent passes on. Do you get notified by the circle? Because I probably don't know all the circles my parents are in. So do I get notified? Do I just get a huge sum in my bank account? Because I've written this beneficiary. I think everyone who's been in employment has written them. And mostly it's the name of the beneficiary, right? Their ID number, if they're above 18, and their phone number. And that's it. So parent has passed on. How do I know there's even something to get in a specific circle?
That is where openness really comes in. Yeah, and also creating system and being organized to the extent that you have an inventory of your assets, you know, and also knowing, you know, which of your assets have designated beneficiaries, because that really helps your family at the end of it. Yeah, so in case there are contacts and the circle becomes aware, yeah, then they will inform the you know, the family, yeah, that this and this and this happened. Yeah, but in case not, then most probably you will see it in the list here. What is it called? Unclaimed financial assets.
Oh my God.
Yeah, and you're searching and you see your father's name appears there, and they had 1,000 shares in Safaricom or any other company or Centum.
What happens by
yes.
doing such scenarios? I've just gone and I've seen, oh, my dad had shares. Do I now start claiming? Do I go and
Yes.
You claim.
you just start claiming?
Yeah.
You start claiming.
It will take a long time though.
I think they need you to present the you know, letters of administration to show that you're the administrator or you're the executor
Of the estate.
Yeah, and there are so many forms that need to be filled. Yes.
Yeah.
So basically, everything else apart from putting your things in order will take time.
It takes a lot of time.
So just put your things in
order.
Yeah, and make people that you love aware that
that
these are the
these
things that you have, and you know, ensure that your records are updated. Yeah, you can imagine if you pass on and you have small kids and you left your properties or you left your pension, your life insurance to your brother who is 60 years old, you know, and you have not updated that. So this brother of yours gets, you know, probably 60 million, while you have a wife and small kids who are there and they basically cannot do anything. Yeah.
Wow.
So it's a really sad situation.
Keep on updating.
Yeah, in the openness scenario, I have something that happened to me recently. So we're in a group of my family members who were thinking of starting a chama, but kitambo sana, a very long time ago. So how this conversation started is I was drinking soda and I had a fan with me. So I asked, guys, mlisema hatutawai anza chama. Then one of my cousins looked at me and told me, see, this is the problem of not having open conversations with finances. Why couldn't you just look us in the eye and tell us, let's start a chama? And one of them talked about now bylaws. We don't just start. we need to have a constitution, we need to talk about when you leave, how you leave. And I said, well, this is such a great thing. As much as it's really hard to start this conversation, it's great to see that people are now educated. We know people will want to leave at some point. We would like to see how people would leave. We would like to have because we can start a Chama for real.
And
we
not
can
have the
start.
excuse of family, because family can be difficult.
Family, the moment money comes in.
With family, it's very
the moment
difficult.
money comes in, that sister of yours, that brother of yours becomes, by their name, becomes Mercy, becomes Judith.
Absolutely. And that's why, you see, in every property or asset that you have, you can actually set your trust as the beneficiary. All right? If you're able to set up a trust, even for the designated beneficiary, the nominated, the nominees, you can set up the trust as the nominee. Yeah? So that upon your death, everything, your dividends go to the trust. It's all about structuring. Yeah. If you have money in the account, you can actually set up and say that pay on death my trust. Yeah. So every money that you had in your account, rather than it waiting, it goes directly to your trust. You really don't have to wait, or your family doesn't have to wait, so to speak. So it's all about how you structure your things. But I am so inclined to trust, and I will keep on talking about trust, because I actually think it is the best way to handle your things. If you have one trust and you're able to, ensure that the titling is on the trust, your designated beneficiaries on the trust, everything you have
in the trust.
You have directed it to the trust, then it makes it very easy and simple for everyone else.
As we close up the Chama and Sako, I just have one question. I think you're going to find it funny, but can I nominate someone for my shares, nominate someone for my land in Chamas? And it's possible. Is it possible?
It is.
Okay.
Yeah.
So you can say Nani can take the land.
Yes,
Nani can take.
absolutely.
Okay.
Yeah, and I think most people, when they think about wills, even they'll ask your random Kenyan, will ni ya kazi gani? They'll probably say mashamba. But as you've seen, that bank account, that wills and trusts, that bank
dividends.
account, those dividends, that company, you need to plan for it. It's not just that parcel of land or that apartment that needs planning for. Okay, I think that's very necessary. And okay,
I was talk about business
continuity, business succession
Thank you, guys.
planning. Yes.
Kiingereza.
Thank you, guys. I was talk about business continuity.
Yes,
and how to ensure that things don't pause.
Yeah.
And it will sound repetitive, but I feel like as we come to close to the end, we will keep on saying this. How do we ensure that the business doesn't pause when you die? When we say business, we can also mean property. Your property will continue as is. Management will work. You just set things. How can businesses and companies set up systems so that things don't pause when someone dies?
Even payment.
So there are so many things that come into play when you think about business succession planning, and at the helm of it is governance. What governance structures have you put in place? Yeah, if it is a family-owned business, how does your constitution look like? Yeah, have you done CEO and management succession planning? All right, have you prepared a pool of talent that in case of 1, 2, 3, yeah, these people will rise to management, because truth be told, not all your children will be effective in management of the company. So you really need to think about that. And even when you're planning about that, we still go back to the buy-sell agreement. Yeah, there are people who say I have worked with Wanjiro for 10 years. She has been very instrumental to the success of this company. Wanjiro is just a manager. So how do I incentivize Wanjiro to want to continue with my business in the event that I am not here? Am I able to consider giving them either equity in the business? How much equity would be good? Even in terms of retirement. When you're thinking of retirement and you have really built this business and you do not see anyone else wanting to take over, but you're basically tired of running this business by yourself, what are the structures that you can put in place? If you have very trusted managers or people that you think are capable, then wisdom would dictate that you give them a bit of and they pay you. They pay you, still maintain control of your business, but there is a certain amount that comes to you, and even you can structure it in a way that at the end of a duration of time, they're able to pay you. You're able to value the business and say, oh, at this point, the business is worth this and this, I'm going to stand in still as a director shareholder, but the business will be paying me periodically. If my business is worth 200 million, the business will be paying me periodically this amount. And after this number of years, then I will move out and you guys take over. So it really depends on how you structure your business. So governance comes first, CEO and management succession planning. Then you have the buy-sell agreements. So there are so many things that come into place when you're thinking about business succession planning.
Okay. And I have something that happened again, another scenario. In Centum Real Estate, you have payment plans, right? So you can pay for a property for 18 months. In the 18 months, the person who was paying for the property passes on. So this is even in business continuity. Now, who pays? What is going to go on? Because I know you are going to say your next of kin and we're going to inform them that, hey, this person had a property here, blah, 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 blah. But now this person did not plan for this. They did not plan to die before they finish paying for their unit. So it's not in a will, it's not in a trust, or even if it is in a trust and they've not finished paying it off, what happens?
You remember when we had this discussion about buy-sell agreements, I said that it is very crucial, to consider what funds the buy-sell agreement. And I gave an example and said it is very prudent for people to have insurances like life insurance upon death, that kicks in so that the heirs or the heirs or the beneficiaries can decide that they are using that amount or part of that amount to actually offset. All right? So in case of individuals, they can have their own insurances and use whatever is paid off to offset. Or they can sell other properties within the estate and use that to offset. So basically you'll get into an agreement with the people the vendors, the people who are selling the property, and inform them that this has happened, however, these are the plans that we have. So if you're not able to offset and the estate is not able to offset, and I really hope you had insurance that's able to offset. If that doesn't happen, then there's the penalty clause that might kick in. But that really depends on the agreement that you have with the vendor. Are they refunding? What really happens if they refund? How much are they retaining?
And
do they really want to refund?
Mortgages have an insurance. There's a protection cover that kicks in at the time of death. So I feel like it's important even for people to have like some life insurance or anything that will cover costs of things that you are yet to pay, yet to finish paying upon death. And as you're coming to the Close your kweli. We had some questions that people had from last episode. So,
okay, I'll start. I found one.
You found one?
Yeah. Is it for trust mainly? Because most people were not aware of trust and the processes and all that, which is a great thing now we are learning. Is it practical for someone with just one rental unit or one piece of land to have a trust, or is it mainly for bigger estates? Because it's a question, a trust for rich people.
I really like how you've ended that, for bigger estates. Yeah, that's why we call it estate planning. And what is an estate? I think in the first episode we answered that. An estate includes everything that you own. Yeah, so real immovable property. Hey man,
kamaji kidogo. Immovable property.
Immovable property, you know, your shambas, your properties. Then you have movable, your cars, your art, your jewelry, tangible intellectual property. You know, so an estate includes everything that you have. So it does not really matter whether it is just one property or you have different estates. It doesn't really matter. Even one single car, you know, can be committed into a trust. So it doesn't really necessarily have to be, you know, a lot of things.
Trust watu wako na pesa peke yake.
Yeah, absolutely.
So I think there's another question in polygamous setups. I think they asked, in polygamous setups, what systems can help reduce fights? Trusts.
We'll just answer the same.
We'll just say
trust.
Yeah.
Because that helps you organize your things the way you want them organized. Remember, we said that in a trust there are actually 4 parties. We have the settler, that's the person who is donating or funding the trust. All right, and it can be you and your wife. Then you have the trustee, the person who is managing the trust. Then you have the beneficiaries. So you as a settler can decide that this is how my property is being divided amongst my 5 houses, you know, and amongst all my children. This is what I'm providing for them. And in a trust, it doesn't necessarily have to be just family. It can be anyone, you know. And also, even when you say, oh, we're just incorporating a trust, how you structure that trust is very important. I've had clients come to me and say, yeah, Judith, you know, I want to fund this trust, but my children are still young. And from the things that I'm leaving, I'll be leaving cash to them. When they attain the age of 18 years old, I do not want all the cash released to them. Because basically they will not be able to use it wisely. So I need 1 million shillings released, or I need 1/3 or 1/4 you know, of the funds released to them at that point. Then I need the next 1/3 released to them when they are 28. Then the remainder of my funds released to them when they're 30 years old or when they're 35 years old. You know, in a trust, you can put conditions, whatever conditions that you want, and it would be followed to the letter.
I remember.
So even when you have a spendthrift, you can say that, you know, this person is not getting 1, 2, 3 until 1, 2, 3 happens. Or they're gonna be getting the rental income, this amount every 2 months, every 3 months. So you can actually set conditions to your trust. You can provide for, you know, children or heirs or dependents who are disabled in a trust, knowing that probably they will not be capable of taking care of their own affairs. So you say, from my property, I want this done. I want their medical taken care of. This is where they will go, you know, get medical attention. This is what I need them to do or to get. Please get a caregiver for them. So you're able to organize your
things in order.
Do you get it?
Yes. Another question. If someone has rural land or a city apartment, do succession processes differ in practice?
Not really.
Okay.
Yeah, not really.
I feel like
it's either your intestate or testate succession. Do you have a will? Do you have a trust? Did you die without organizing that? Yeah. So it will just differ in terms of the procedure, depending on how you organize yourself.
Okay. So, and I think another question, Mercy, you were asking is, could any region be harder, like the succession process be harder than the other? Would the property in the city be harder to succeed? I hope that's the right word. Yeah? Yeah, the city property or the one in the rural area, which one is harder?
No, I don't think that question really comes into play. If it is not contested, then it is not hard to succeed. Do you have the title? Yes. The titles, how are they registered? Is it in your name? If it is in your name, did you organize who needs to take it? If you did not organize or cater to that, it goes through intestacy. If you organize and by will, then it will devolve to your beneficiary. If it is through a trust, then it is automatically registered in the name of the trust. It belongs to the trust. It doesn't even belong to you. Yes.
Okay. Yeah. Okay. So we've spoken about.
So it's procedure. The difference would just be procedure. The second difference would be, is it challenged? Are there issues surrounding that?
The property.
Yeah. Is it free property? It has to be free property. Yeah. Because remember also, you can't will out matrimonial property. And just will it out. I mean.
Yeah.
And for anyone who's confused, you're wondering, what is matrimonial property? What is a trust? You see last week's episode, part 1 of this episode, go back so that you can be able to have a free-flowing episode today. And then there's another one that we almost forgot. Gifting.
Yeah.
Ooh.
So we have the trusts, we have wills, we have the processes, buy-sell agreements, we have all these things, but I am alive today and I have the property here. I am sure I will not be using it in my lifetime. I want to gift it. How does the process of gifting property look like in Kenya?
Yeah. So gifting property, basically, you do not have use for this property or you have decided to gift it out to someone. You'll do a gift deed and you will transfer that property to the name of the person that you are gifting to. Yeah. So the property belongs to them.
That's
basically, yes.
You'll just go to ministry.
Yes.
And show them the...
And do the transfers, the normal transfers.
Yeah.
And when they ask for consideration is the money that you're paying.
Yeah.
Because for a sale to be authenticated, there has to be an offer, acceptance, and consideration.
Yeah.
All right? Consideration usually is the money that you pay. So consideration in contemplation of love and affection. So you don't need to basically state how much because it's a gift.
Wow.
So you basically do a gift deed.
Wow.
So there's an advantage of gifting when you're alive.
Yeah.
So I have a question. I've gifted Edna because I love Edna.
Yeah, thank you.
Yeah, you're welcome. And then later on, upon my passing, maybe, can people come and contest, or once it's done? It's done.
Once it's done and you have followed the proper procedure to transfer the title to her, then that's it.
That's it.
Yes.
So there comes the advantages of gifting. What are the advantages?
It does not form part of your estate. Okay. Therefore, it cannot be contested because it's a gift.
Yeah.
Yes.
Okay.
So I have... so the last question in terms of gifting... yes, I can gift in health, but what of the case where I am very old in my deathbed or I'm in hospital? Can I? So
those ones are called gifts in contemplation of death. That is when you actually think that you're gonna die and you decide to gift. In Kenya, gifts in contemplation of death can only be effected if it's a movable property. Movable property, not land. These are gifts that are made or are donated, at the point where someone feels like they might not survive. In case that person survives, then it reverts back to the owner. But gifts in contemplation of death, there are a few things that you need to prove. Yeah, that first, it's movable property, it's not immovable property. If it's immovable property, meaning it's a property or land. Land is immovable property. Things that cannot be moved, immovable property. Then you need to show that you actually signed the transfers and all that. Yeah.
Okay.
Immovable property cannot be perfected posthumously. So you cannot say it was a gift and then you want the court to help you, with the transfer, get it and all that. That's why we talked about gifts first. But if it's immovable property, it's a car, it needs to show that actually it was in contemplation of death, you felt like you would die and you actually died, that the subject matter, you transferred possession of the subject matter. If it's a car, the logbook, the car keys and all that. Yes. So basically that. You transfer the subject matter, you contemplated death and you actually died. But it is upon the donee, to prove that this was a gift in contemplation of death.
Okay. So that's...
I think that's the end of gifting and trust and
buy-sell agreement. Everything you need to know about your property when you're gone or when you're incapacitated, or these things can happen any day at any time. So you should not be afraid of preparing. You'd rather prepare.
So, and by the way, as we close, Judith, is there anything you'd like to mention?
In terms of trust, I would say don't be local, think global. Right? And you can also, rather than just considering local trusts, you can consider offshore trusts. And basically this means that registering a trust in a jurisdiction that's not your own country. There are many tax advantages to that, but I wouldn't go into that. But in case you have properties situated in different countries. Then you can consider having an offshore trust. That's able to hold these properties. In Kenya, the trust would be considered as a non-citizen. So there's a way in which you if it is a leasehold property, then the trust can have it. So there is so much structuring that goes into that. But it's safer for people who are either high risk, in terms of creditors. They feel like, creditors can come for their properties, even the locally registered trust. It is good for people who have very high value properties. So it's also an asset protection mechanism. And also people who have different properties in different jurisdictions. You can actually consider offshore trusts, and we help you do that. We have partners in different countries that we partner with. Yes.
Pay your professional, guys.
Pay your professionals. And finally, so in planning my exit, what should I have in order?
In planning your exit, it's very important to consider first, what structure are you taking? Are you doing a will or a trust? I'll tell you to do a trust, definitely. And will out the things that you feel like you really need to will out. But the basic things, have them in a trust. Titling of your assets. Ensure that your assets are titled properly. If it is a joint ownership, ensure that first that was your intention. All right? If it is a tenancy in common, ensure that you have provided sufficiently for the person that's going to take over, or actually have the trust on, your share in a tenancy in common. Your designated beneficiaries and your nominations. Yeah, ensure that you write there. You have the right people. As designated beneficiaries to your life insurance policies, to your retirement, to your pensions. Yeah. So titling, keeping an inventory, be open with your family, have proper governance structures, buy-sell agreements. What else? Pretty much.
Have your things in order.
Have your things in order and keep on updating. Yeah. Keep on updating. Yeah. Ensure you have proper corporate structuring. You might feel like it's a bit expensive. It's not really expensive. It's really affordable, but it saves you a lot of headache. Yeah. Don't just register companies for the sake of registering companies. Ensure that you have a lawyer who can do proper corporate structuring for you. Yeah, basically.
And my parting shot for everybody. I know the episodes are extensive, especially this one. We have part 1 and part 2, but I would advise everyone, this is a case-by-case situation. You might think something works for you, and maybe it doesn't. So go to the professional, go to Judith. You might have property that you may think needs to be structured in this manner, but she'll advise you otherwise, even because of the type of beneficiaries you have. So I would advise, as you listen in, and I'm sure there are many other questions that we may not have answered to in the episodes, ask her, pay her, visit her, email her, call her. She can plug herself where she stays, where she is. If you don't want to talk to us directly, because these are private matters, you can get her at
Kamoing and Company Advocates. We're located at 2 Rivers, Southern Towers, on the 3rd floor, suite number 2. You can reach me on 0733 281 337 or 0723 281 335. We are your commercial estate and business planning experts.
Yes.
Yeah.
Thank you so much. Thank you so much for giving the time and giving the knowledge. We really, really appreciate it. And I'm sure the listeners also at home
do appreciate
it.
Yeah.
And we hope everyone has a will and a trust at least.
Yeah.
As we close the episode, at least have a will and a trust.
Because where there's a will,
there's a way. There's a way and there's trust.
Yeah. Right? Okay.
So I think this is the end.
Yeah, of the episode. This week's property of the week is Riverbank. Mercy, tell us.
Wow. Riverbank Apartments in 2 Rivers. 1 bedroom, 2 bedroom, 3 bedroom apartments starting from 17.4 million, 25.6 million, and 37
million.
I think we're going to have
the squeeze back with the amenities.
Have all the details and the amenities. And it's in the heart of 2 Rivers. Currently, we are at full occupancy, I believe.
Yeah, in phase 1, full occupancy, fully sold out. No one is reselling. Phase 2,
that's what we are selling.
What we are selling right now. So you can call us or DM us, write Riverbank in the comment section. We will be sure to get back to you. And that's it. You can follow us on TikTok, Instagram, and Spotify at The Real Conversation Podcast KE. On YouTube, you're here with us. So that's Centum Real Estate. Yes. And we are so happy to have you here again. See you next week.
In the next episode.
Same time, same place.
Bye-bye.